All right, so Mr. Henry, listen, I'm going to put you under oath and ask you some questions, okay? It's only going to be as it relates to the state's offer, and it's only as to make sure that you understand the state's offer and you understand the charges that you're facing here. We're not going to talk about anything else. So just listen to my questions and answer the questions, okay? Raise your right hand. You swear to tell the truth, whole truth, nothing but the truth. Okay, you can put your hand down. Please state your full name. How old are you? How far did you go in school? Do you read and understand the English language? Are you presently under the influence of any drugs, medication, or alcohol? Have you ever been treated for a mental illness? Are they giving you any medication in the jail right now? All right. How are you feeling this morning? Your head is clear? You understand what's going on? All right.
We just got a major update inside the YNW case. Today in Broward County, prosecutors laid their cards on the table, offering Cortlen Henry, also known as YNW Bortlen, a plea deal that could change everything.
All right, so Mr. Henry, listen, you got two cases. I'm going to go one at a time. In case number 19, 1871 CF10A, right now, you're charged as follows. Counts 1 and 2 is murder in the first degree with a firearm. Those are capital felonies, which means it's a mandatory life sentence. If the jury convicts you of count 1 or count 2 as charged, that's life in Florida State Prison. I have no discretion. Count 3 and count 4 are accessory after the fact to murder in the first degree. Those are each first degree felonies. The maximum penalty for each of those is 30 years in Florida State Prison, okay? In your other case, which is case number 23-10643 CF10A, you're charged as follows. Count 1 is tampering with a witness in a capital felony. That is punishable by life in Florida State Prison, all right? As the maximum penalty. Count 2 is directing the activities of a criminal gang. That's a first-degree felony punishable by life, so the maximum penalty there is also life in Florida State Prison. Count 5 is conspiracy to commit tampering, and again, as it's charged, that is also a life felony. The maximum penalty is life in Florida State Prison. And lastly, count 7 is unlawful use of a two-way communication device. As that's charged, it's a second-degree felony. The maximum penalty is 15 years in Florida State Prison. So right now, as to all the charges that you're facing, the maximum possible penalties are as follows. It's life in Florida State Prison, followed by 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 75 years in Florida State Prison. Do you understand the charges and the maximum possible penalties involved? Okay. So, Mr. Henry, the state is telling me that they're extending an offer.
Let's be clear about what's at stake here. Bortlen is charged with 2 counts of first-degree murder with a firearm. That's automatic life if convicted. Add in accessory, tampering, gang activity, conspiracy, and he's staring down multiple life sentences stacked on top of each other.
And the offer is as follows. In case number 19-1871 CF10A, they're going to null pros or drop counts 1 and 2, both first-degree murder charges. Okay. And in exchange for that, as to counts 3 and 4, in that case, the accessory after the fact to murder in the first degree, you're going to plead no contest to both of those. And as to the 4 counts in case number 23-10643 CF10A, you're going to plead no contest to all 4 of those counts. And in exchange for all of that, the state is offering that I would adjudicate you guilty and sentence you to the bottom of your sentencing guidelines, which is 195.45 months, about 16. It's a shade over 16 years and 3 months. 16 years and 3 months. All of those sentences will run concurrently, that is at the same time with each other. I would give you credit for all the time that you have served, understanding that you have a lot less credit time on the 23 case because it's a newer case. So that is what would be controlling. Whatever credit time you have on the 23 case, you can subtract that from the 100
I think he actually has more time on the 23 case than the 19 case out of custody.
Oh, okay. Well, whichever case you have more time, less time in custody, that's what would happen. And you get the credit for all the time that you've served. And again, that sentence would be 16 years, a shade over 16 years, 3 months in Florida State Prison.
The state is willing to drop both murder charges if Bortlen pleads no contest to the lesser counts. In exchange, the judge would sentence him to 16 years and 3 months in Florida State Prison, and those sentences would run together, not back to back. On top of that, he gets credit for the years he's already spent behind bars, which means Bortlen wouldn't serve the full 16. He could be walking free in his 40s instead of never leaving prison again.
I would have to order restitution. The state would tell me the amount of that restitution. That restitution would be joint and several with any of the other co-defendants if any of the other co-defendants were convicted at trial or entered pleas. In other words, the restitution only has to be paid once, but each person is responsible for 100% of it. All right, but as soon as it's paid, it's paid. I would have to impose mandatory court costs in each case, and I would have to impose a mandatory cost of prosecution in each case, which is $100. So, Mr. Henry, do you understand the offer that the state is making to you? Okay, the 16 years, 3 months, and a shade more. So I'm going to pause on it at this point, Mr. Henry. It's going to give you some time, whether that be tonight or also over the weekend, to talk to your lawyers about it, make sure they answer all your questions, talk to your family about it, so you can make a decision as to what you want to do.
This deal puts the pressure on. Does Bortlen roll the dice at trial alongside YNW Melly, knowing life is on the line? Or does he take 16, swallow the time, and guarantee he lives to see the outside again? That's the decision sitting in front of him right now.
Now, let me explain this to you, sir. I can't make the state make you an offer, and I can't make you accept any offer. I'm just the referee, okay? This is a business decision between you, your lawyers, and the state. And if you want to accept it and resolve both cases that way, that's fine with me. And if you want to have a trial in both cases, that's fine with me too. It doesn't matter to me in any way, shape, or form. But whether it be tomorrow, when I see you tomorrow, and then Ms. Wilcox, she already has tomorrow at 9 o'clock, that'll remain on. But I'll put them on both cases as well next Tuesday, which is September the 9th. Let's just call it 1:30 in the afternoon. September the 9th at 1:30 in the afternoon, we'll call it trial status in both cases. That's when we're gonna have to finish this conversation, Mr. Henry, and you're gonna have to tell me that either that you understand the offer that the state's making, that your lawyers have answered your questions about it, and then you're gonna have to tell me what your decision is, whether you want to accept the offer or whether you want to reject the offer. Mr. Henry, the one additional thing that I like to talk to people who are sitting in this situation that you're sitting in right now to have this conversation is as follows. The reason that I'm doing this is because I want the record to be clear what the state's offer was, and the record to be clear that you understood it and that you had enough time to talk to your lawyers about it. You had enough time to talk to your family about it. You weren't under any pressure to make a decision, whatever you thought was in your best interest. Because it goes kind of like this, and I'm sure your lawyers could speak to it better than I can. If you accept the state's offer, that's fine. And again, if you don't accept it, that's fine too. But if you don't accept it, and one of these trials doesn't go your way, and you end up with life in Florida State Prison, which is a mandatory sentence on a lot of these counts, usually people in that situation, then they'll file what's called a motion for post-conviction relief, and they'll say, hey, Judge, my lawyer never told me. I didn't know that I could resolve all this for 16 years and 3 months, and if they would have told me that, I would have done it. And now I'm sitting here with a life sentence. So that's the reason I'm having this conversation now, so the record's going to be crystal clear on that issue. If it doesn't go your way, that argument's not going to be available to you to come back and say, hey, my lawyers didn't tell me about this, or I didn't know about this, so that's why I'm talking to you about it now. So, Mr. Henry, do you have any questions for me about the maximum possible penalties involved and what the state's offer is to you as we're talking about it right now? Okay. All right, so I'm going to pause on that part of the conversation, and we'll finish that other part of the conversation either tomorrow or next Tuesday afternoon.
This is the trial room powered by Daily Plug. We'll keep you locked on every move inside this case. Hit that subscribe and drop your thoughts. If you were in Bortlen's shoes, would you take the 16 or risk life?
Hey.
Plug talk.
You're looking at the
plug.
understand how the fuck my plug talk. Ooh, you know I got it.
Brought to you by Daily Plug.
Yeah.